This is the American Law Journal.
You got that out-of-state job. Congratulations. Now you want to relocate the children of your divorced marriage across state lines. What are the odds that the judge says no? Good evening. I'm Christopher Naughton. Welcome to the program. Child support, custody, visitation, relocation. They're always tough issues, but take it out of state and the degree of difficulty has just gone up. Three great guests with me tonight. Let's go ahead and meet them. Bonnie Frost hails from Einhorn, Harris, Asher, Barbarito, and Frost. Bonnie in practice several decades now. She's been a member of the New Jersey Family Bar Association. She is the chair of their matrimonial mediation and arbitration department. 27 published cases to her credit. David LaDove returns to the scene of the crime. Although Dave, a slightly different name under your name, now with Obermeyer, Redmond, Maxwell, and Hipple in Pennsylvania. He is chair of their family law section. Dave, of course, past chair of the Pennsylvania Bar Association's family law section, and he has got a great blog. And Don Spry is with us this evening, as he has been for almost 25 years with King Spry, Herman, Freund, and Fall. And Don, much like Bonnie and Dave, has taken cases to the very highest courts in his respective state. For over 40 years, Don has been running. He's a jogger, gets out there, keeps him sane in the practice of law. Folks, we're not taking your telephone calls tonight, but if you want to reach us, write us at info@lawjournaltv.com. Well, before we get to relocation, we really have to talk about the state of custody, because there was a time there was really no such thing as joint custody. It was rarely heard of. And then, over the last 10 or 15, maybe 20 years, joint legal custody became all the rage. Now, it seems that the norm is becoming shared equal physical custody. Is that the norm, Dave? Is that what judges are looking at and liking today?
I guess, Chris, the issue becomes it's like a pendulum. I think that it's now swung to the side of we start with a 50-50 arrangement, even though that's not the law in Pennsylvania. A lot of judges start there and say, why shouldn't it be equal? I think psychologists have had a lot of input in that, in trying to explain that children need both parents. So if they need both parents, why shouldn't it be an equal amount of time?
You know, speaking of a psychologist, Dave, here's a quote that we actually included this in a program a few years ago. Let's see if it still holds true today. Relocation laws are still more lenient in favor of the parent who has primary physical custody of the child. There are rulings supporting parents who relocate simply on the basis of unhappiness with the present location or depression based on an inability to visit with relatives. One still encounters court systems, such as Pennsylvania, where the court speaks out of both sides of its mouth and often makes relocation quite difficult. Still true today, Don?
I think it's fact specific. If you have a circumstance where both parents are very close to the children, they both spend a lot of time with the children. If it's a shared custody arrangement, I think it's going to be very, very difficult to relocate. On the other hand, if it's a family where the non-custodial parent is not spending a lot of time with the children, and the person who wants to relocate has a new job, higher pay, those sorts of things, I think it's more likely in that circumstance.
So is it really all about the money, Bonnie, or mostly about the money? I mean, it used to be someone gets a new job, they're making more money, and the relatives are in this other state. And I don't want to say that the court just rubber stamped that, but those seem to be the driving factors. Aren't they the same thing today?
Well, in New Jersey, you still have to have a good faith reason to move. And that could be,
more pay in relatives.
More pay in relatives could be the good faith reason. But then you have to prove that it's in the best interest of the child to move and the child will not suffer from the move. Before an opinion that came out about 10 years ago, that we had to talk about visitation schedules, parenting time schedules, which quite frankly still makes a lot of sense because you have to balance the move and the child away from the other parent with how are they going to see the other parent, how often are they going to see the other parent. But I definitely agree with Don that the more time you spend with your child and the more you can prove that to a judge, even if it's not a shared custody arrangement, I think the more difficult it is for the other parent to move.
Right, even if you don't have joint, shared physical custody.
Right.
And Dave, what would you say the percentage of custody cases in your practice are literally shared physical custody, where the kids are literally being ferried from one house to another during any given week?
It's still the minority, Don and Chris. We have about, I'd say somewhere around 20-30% are shared equal custody arrangements that
Okay.
I see.
Right. That's still a lot more than a few years back, 10, 15 years back, though, I would think.
I would say 5 to 10 years ago, it probably was 5 to 7%.
Right. Okay.
My experience is similar to Dave's as far as the percentage. I mean, shared custody just doesn't work in certain circumstances. I mean, if you have
Shared physical custody.
shared physical,
Right.
if you have one of the parents that's working all kinds of hours or travels, can't be around enough to take that 1 week on, 1 week off, or however it's structured, it's just not going to happen. You have to have both parents available, and as Bonnie said, you get back to the best interest of the child, and you're not going to do it for the best interest of the parent. It has to be something that works for the.
Well, that's what they say. It's not supposed
Well,
to be
that's
for
the
the best
law.
interest. Right, exactly.
Well, I find it's
Right.
very interesting that Pennsylvania has the presumption, if what David's saying is that you start out with 50-50, because I still think it's very rare.
It's just, I think a lot of judges, as we all know, every election cycle, new judges get elected, and where do they get dumped but family court? And my experience is that there's no presumption, but slowly but surely, what's the easiest thing to do? And the easiest thing to do is, oh, well, maybe I'll start there and then I'll move off of it.
And Dave, is there also a presumption that shared physical custody is still the best path to take it? I mean, arguably, you could argue a case that's not in the best interest of the child, but does the court start with that presumption as well?
Again, I think it's judge specific or judge sensitive. There are a lot of judges who, while they really don't like custody litigation, they think it's the worst thing that can happen to a kid. So they want to try to resolve it as quickly as possible and avoid that stress for a child. So they're going to make the easy call and say, okay, why don't we start here? Tell me why it doesn't work.
I do see when there's not shared physical custody a lot more partial custody time than it used to be. You know, it used to be like a Saturday morning to a Sunday night. That's been expanded in my experience.
Part of this also are roles. You know, last year, you folks were here, we talked about alimony. And we talked about, changing roles with women. I'd probably get all three of my guests tonight to stipulate to the fact that politically, economically, maybe even socially, that women have been marginalized and they're still catching up. One exception to that would be, historically, when it came to child custody. If the mother wanted the child, 99 times out of 100, the mother got the child. But how does that kind of dynamic work today when it comes to relocation? Because it's not ipso facto anymore. So if a woman wants to relocate, she's got a better job. She's got family and relatives out of state. The judges aren't knee-jerking anymore saying, it's the mom, go with the mom.
I think that they are saying we're going to look at the best interest of the child. And again, to reiterate, the more you're involved with the non-custodial parent, the less likely it is that the child's going to move. However, in New Jersey, it is easier legally, when you read the cases, it's easier legally now to move. Whether in practice it really plays out to be that way, I'm not so sure.
And why is it easier to move legally in New
Because
Jersey?
they changed the legal standard.
Okay.
And the legal standard is, will the child suffer from the move?
Okay.
And that's
It's almost like the burden is shifted. of
Yeah,
sorts.
that's a whole different standard. You know, how can you say that a child's going to suffer if living in Charleston, South Carolina, or Denville, New Jersey?
Yeah, I just wanted to jump in Pennsylvania a couple years ago, our relocation statute, custody statute, put in 10 factors for relocation. So it now gives the judges a roadmap as to, here are 10 factors, and they have to go through each and every one of those factors and analyze it to determine whether a relocation should or should not occur.
You would agree with your compatriots that gender is not as much of a factor as it used to be?
No, clearly the guys, if ever the men have made an inroad into the shared physical custody, because that never happened before, and the equal time, and if I can just get to the equal time, when you ask Bonnie, it's about the money, I just wanted to slip in one little point here. What also motivates people who aren't so altruistic is that once in Pennsylvania, the non-custodial parent has more than 40% of the time, which basically For those of us we do everything on 14 nights or a 2-week block of time. Once you get that 6 out of 14 nights, it's 43%. And as a result of that, you now get a deviation downward on your support. You have 50-50, it's a greater deviation. So while I don't wish to cast aspersions on people's intentions and motivations, money is still a factor.
Let's say a person does move across the state line, New Jersey into Pennsylvania. And the divorce took place in New Jersey. And
that's the most important point.
That is the most important
Right.
point, okay? So even the custody order, so help me out here. Divorce takes place there. That's really the linchpin. That's where it starts.
And custody is determined there, so that you have one custody order.
Right.
And then that person wants to move. Then the modification of the custody has to be established where the first order of custody was entered.
Yeah, if that person moved to Pennsylvania, New Jersey would still be its home state.
Yeah.
So Pennsylvania is not going to accept jurisdiction absent some emergency situation. But if that child's lived in New Jersey for 6 months, just moves into Pennsylvania, you're not going to successfully file an action in Pennsylvania. They're going to send it back to New Jersey.
So if someone moves across the country and they're in California, had a divorce in New Jersey, if that person wants to modify that support, they have to go all the way back to New Jersey to do
Right.
it? Dave,
If the child's still here.
Well,
If the
obviously, yes,
the
that's what I'm
child's still in
saying.
New Jersey.
It shouldn't
Okay.
It shouldn't come as any surprise to anyone that our judges are somewhat parochial, and a judge feels that once he or she has a case, it's theirs for life. I've had situations just like what you're talking about, where the divorce happened in Philadelphia. The original custody order was in Philadelphia. One of the parties moved out to California, and that party got custody of the kid so they could move, but Philadelphia still retained jurisdiction because one of the parents still lived there. And as long as one of the parents still lives in the quote-unquote home state, very rarely do the courts give up jurisdiction.
So why in our nation, about some 20 odd years ago, create, I touched a good nerve
Now,
here.
where are you going?
Now create the UCCJEA, which again you see up on the screen here, the Uniform Child Custody Jurisdiction and Enforcement Act, and the UIFSA, which is the Uniform Interstate Family Support Act. I mean, obviously the cornerstone of family law practice must be full faith and credit. You've got to be able to honor the laws of each other state. What do these laws do, and how do they impact what you're doing today to make sure that if people do move from state to state, that there's some degree of predictability in their family law situation?
I mean, I think the original purpose of the Custody Act was to prevent what we call forum shopping, that you run from Pennsylvania to another state that might give you more of an advantage in the litigation. So that act said that the home state of the child is where they've lived for the last 6 months. With the Federal Support Act, I think that was literally Congress was concerned about the fact that people were not paying their support, so taxpayers paid it. So they wanted to put teeth in it and make sure that you had enforceable orders and that you couldn't take that Pennsylvania order and go to Georgia or anywhere, some other state, and get it modified to a number that was, better for the payor.
Well, and that's what was happening. For example, you could take a New Jersey order to Florida, and Florida would say, well, I think, Mr. McNaughton, you're paying entirely too much. So I'm the Florida judge, and I'm going to say you only have to pay $50 a week instead of $200 a week. So that man would then, or that child would have a Florida order, and then
New Jersey.
add a New Jersey order. But the child's in New Jersey, and the Florida father, who's living in Florida, is only having to pay $50 a week because he was able to get the ear of the Florida court. And so the UIFSA says, we're not going to let you do that because it's really another avenue of forum shopping.
Relocating in some ways has gotten a little bit easier, for example, because of this, the standard that New Jersey's come up with. But at the same time, it seems like there's a whole lot more in one's arsenal if they want to throw a bomb or two in there to keep a person from moving. I mean, as we were talking about, shared physical custody or some degree of shared physical custody, spending more time with the kid. It seems like you've got a lot more to work with if you do want to stop it from happening.
I think that is the law. However, if you are fortunate enough to win at the trial level and relocate, as long as the judge makes enough findings, she won't even ever have to go back to New Jersey, because we had a case called McKinnon versus McKinnon where the trial judge said that the mother could go home to Japan with this young child and could move there. And the father said, but I don't want that child to go, because if in fact she doesn't abide by the orders you entered here, Judge in New Jersey, I can't get Japan to enforce the orders. And because Japan's not a signatory to the Hague Convention, that child could go to Japan and it'll be in a black hole if the mother doesn't decide, if the mother decides, I'm not going to obey the New Jersey court order. And New Jersey let her go, and they said, we don't care.
Wow.
What happened? Do you know the postscript?
I know I should follow up on that. I'll bring that up
Curious
next time.
whether the child ever came back.
I think the same kind of case in Pennsylvania. Same outcome, do you think?
Well, that would
I'm
be...
actually incredulous that was what the outcome was.
I mean, you make these arguments every time there's international travel. If you have some fear of abduction, because not every country is a signatory to the Hague Convention, and even if you are, it's a hassle, it's a problem. So, posting bond, for example, mirror orders where the other country has to enter the mirror order of what's entered here to be able to enforce it. But if somebody takes a child internationally and doesn't bring them back, it's just a long, expensive process. So.
Chris, I had a situation, and I'd much rather talk about my wins than my losses, but where mom was allowed to return to Israel. The family had been here for a number of years as the father went through med school and residency, et cetera, and the court let her go back to Israel. I know you sat there and said it's incredulous to you, but there are many judges who feel that if the primary custodial parent wants to relocate, I'm not saying they always let them, but there are cases that they do. I agree with Don. There's lots of things that you can advise your client what to do or how to do it, but you got to do it more than after the petition was filed. And very few people come in for, I'll call it, custody planning or divorce planning. They come in after the fact, after that petition for relocation was filed, and now all of a sudden you're supposed to make this all go away, and it's not so easy.
And that's a practical problem. As Dave said, if you can plan some of these things, I don't mean in a devious way, but if the relocation petition has been filed, the facts are there.
Yeah.
And if there's been a shared custody arrangement for a number of years, and you're trying to relocate and you're representing the person who wants to relocate, that's probably that one relocation meeting you have that week that says you're not going to win.
Right, because here it is in black and white.
Yeah.
And here's what you agreed to.
Right.
Mm-hmm. And if the judge reads these words, there's no way he's going to permit this child to go to another state.
Very unlikely, unless, yeah.
And and Dave, and this is really so very important, because when it comes to relocation, you probably see a ton of mistakes, and by the time any of you see somebody, it's a little too late, or they've made your job that much harder, and it's going to take longer, and it's probably going to cost them more. So when you're going to prepare for relocation, you're going to tee it up. And again, I love what you said, relocation planning. You don't see that. We see estate planning, marital estate planning. If they could tee it up, what do you tell them to do to get the situation right, so by the time we do get in front of a judge, if it goes that far, that you're ready to go?
Well, again, it's going to depend upon which side of the fence. If I'm representing the parent who wants to go,
yes,
then what I'm going to try to do is steer them to go to a place where there's a significant economic benefit, where the schools and school system is superior to where they were before in either Jersey or Pennsylvania. I'm going to try to get them to go someplace where there's support system like grandparents, aunts, uncles. These are all the factors that the court's going to look at to balance those different 10 factors. And then I'm going to tell the person that for like a 6-month, 8-month, year period of time, whenever the other parent is asked, can I take the kid for an extra day here or there, always say yes, because one of the biggest factors is who is cooperative and who is the best at encouraging a relationship between the other parent and the kids. And you have 4 or 5 of those examples. Those are real great testimonial tips when you get that person on the stand, the other side of the stand, and say, well, didn't Sue allow you to have the kids this time, this time, this time? Oh yeah, she did. They don't know why, but they allowed them. So, that's when you talk about planning.
I think the other point, to add to what David has said, is that hopefully you're moving to a place that's easily accessible for the other parent to get to, such as Newark to Chicago, because there are lots of flights. It's one stop. The kids can get on the plane, go back and forth fairly easily. It's not a long trip. So those are kinds of things where you can present the plan to the judge. Well, look, there are 10 flights a day out of Newark to Chicago. It only costs $225 round trip, we wish. But, that those are the kinds of things versus I'm moving to, I don't know, Midland, Texas. I don't know if that has an airport, but I don't think Newark flies to it. So that those are the types of facts that if that move is to a place that has a hub where travel's easy, so the kids can go back and forth as well as the parents.
Makes the judge's job a little easier.
It makes it easier.
Right,
yeah.
It does. Hey, how does Skype and FaceTime now come into that? I know with visitation, but I'm wondering how some of our modern media comes into maybe helping your case. Again, let's say you're looking for relocation, saying, look, the kid's still going to have a connection with dad. She's going to be FaceTiming every night.
I had that in a custody case 20 years ago. And
was there such a thing 20 years ago?
Yeah. Yes.
Maybe Skype, you're right.
It was Skype.
Okay.
But the psychologist at that point was saying that the younger the child, the child can't hold images in his or her head for long periods of time, and they don't have a concept of time. So that when you have a parent who moves away, that move could be to Alaska, to be the North Pole. The younger the child is, because they don't have time concepts. And so that the Skype would be a way to keep the face, ever present in that child's mind, because the younger the child is, sometimes they forget. Mm-hmm. When we talk about children, they're not only 11 and 12 years old, sometimes they're 2 years old.
Sure. There is, in Pennsylvania, a number of cases where the courts have really come right out and said Skype time or FaceTime is not the equivalent of physical custody.
Yeah.
Whenever you're propounding a relocation, you throw those little things in and, dad can Skype and say goodnight every night. The judges are like, I don't think that's the same thing.
That better not be the strongest part of your argument.
That was my experience too.
Right.
I think it can be helpful, but it's not going to replace visiting and being with your kids.
Well, let's end up where we began. Relocation and your practice. Is being on a river town or being close to another state, does it really impact your practice that much? Do you have to have more alliances with out-of-state practitioners? And again, I hear you clearly. It's where the divorce took place, where the kid is located. But I would think of some of these river towns, and you're all pretty close enough to both to the line, if you will. It's got to come up. It's got to be a factor.
It absolutely does, and I'm very happy to be good friends with David and Don.
I feel the same way.
Because sometimes it will shift, right? Sometimes the jurisdiction will. In fact, there are probably cases where the jurisdiction was in New Jersey, and all of a sudden, through not any nefarious motives or something illegal, but the jurisdiction has shifted. Same case, same players. Now it's in Pennsylvania instead of New Jersey.
Or we'll get a phone call and say, I live here. I have a custody order in Pennsylvania. I want to come in. I want to change custody, or I want to change the child support. We'll say, well, you have got to go back to Pennsylvania.
Right.
And if I may, our firm has a Cherry Hill office and a Philadelphia office. And a number of the attorneys are licensed in both states. So we're going back and forth on a regular basis, handling matters in both states. And my point of saying it is that, yes, we have cases where the divorce may have occurred one state, but the custody order's another state, the support order's, one state, custody order's another state. It's very typical when you live near those borders, and as people know, driving from Philadelphia to Cherry Hill is all of 15, 20 minutes. So that could even not be a relocation, as Don was saying, in Pennsylvania, because it may not really impact on the time of the non-relocating parent.
And final question is, how do you handle your clients emotionally? Because, look, we understand equitable distribution and matters dealing with money, alimony, et cetera. They're searing emotional issues. But I've got to think that when it comes down to relocation, and there's a real fight here, and the two parents can't agree, there can't be anything more tenacious than a parent trying to hold on to a kid or another one trying to bring them to a better life than in a relocation matter. Am I right about that? And how do you handle the client emotionally? Because it's got to be that.
Well, I think the relocation from Pennsylvania to Chicago or Los Angeles, a relocation like that, there's a winner and there's a loser. And it is traumatic. Either the person that wants to relocate, if the judge says no, that person has to make a decision, because you can't stop somebody from moving. You can stop them from moving with the kids. So that person has to make that choice. Do I still go and not take the kids, or do I stay in Pennsylvania?
And you've had that conversation with many clients.
Yeah.
What do you want to do? Should I stay or should I go?
Yeah.
Because if you go, you may be going by yourself.
You can. It's pretty hard to guarantee anything in a relocation case if it's a close case.
Right. Bonnie?
I think the one thing is, if you lose, if you're on the losing side, if you also happen to be the higher wage earner, you have a better shot of maintaining a relationship with your child because you have more ability to make those trips and pay for those trips, whereas the person who may be the lower wage earner can't always do that.
And the court takes that into account, obviously.
They do.
Right.
They do, but it's...
You can afford to fly to Chicago, Mr. Smith, what have you. And Dave, what about you? How do you handle this? Because you know that it's emotionally wrenching when maybe a kid is going to be living 3,000 miles away from his parent.
My experience is that judges have always said that relocation are the most difficult cases because it is, as Don said, a winner or a loser, or it's a horrible end result because the kid is now going to be, hundreds or thousands of miles away from another parent. And when you say, how do you handle it, as both Don and Bonnie said, you can't guarantee anything, and you just have to say, you counsel them, do you really want to try to relocate, or can you wait till the kid's older? Can you wait until something else changes? But it's gut-wrenching. I have one right now where we're in Superior Court and mom was denied the ability to relocate, and she waits every day for that decision to come down, and I can tell you there's not a peaceful night in that household.
I want to thank my three guests tonight. Again, just picking the brains of some great attorneys who've been at it for some time. Bonnie Frost with Einhorn Harris, Asher, Barbarito, and Frost, one of the largest, if not the largest, family law practice in the state of New Jersey. David LaDove with Obermeyer, Rebman, Maxwell, and Hipple. He chairs Obermeyer's family law section. And Don Spry with King Spry, Herman, Freund, and Fall, 24, maybe 25 years strong here on the American Law Journal. For all of us here at ALJ, thanks for joining us this week. Until next Monday night, case closed.
This week's American Law Journal has been made possible in part by King Spry, serving its Pennsylvania clients in family law, business, personal injury, and school law for over 30 years. Einhorn Harris, a long-standing community law firm with the largest family law practice in New Jersey. And The Legal Intelligencer, the nation's oldest legal newspaper for lawyers.